All right, the parties on Posada. Hello.
Hello.
So why are you before me today?
I violated my no contact order.
And why would you do that?
My concerns are my daughter's mental health.
Well, no, but there's a no contact order in place. And there's a reason there's a no contact order in place. There's a no contact order in place with this court. And on the civil side, there's also a no contact order. And then my other issue is then the grandmother starts blaming the party you were not to have contact with, telling them it's their fault that if you go to prison, and it's not, it's your consequences. So I don't know why you're violating my conditions that I have set for you. And there's a reason why I put those conditions in place, and your attorney knows there's a reason why I put those conditions in place, and you just want to violate it and pretend like you're violating it for some benevolent reason, and you're violating it because you want to violate it. Because if you cared about these people, you wouldn't be in this position anyway. And the fact that there's another case on the civil side that has absolutely nothing to do with this, that's all you. And so did you get a chance to read what your mom is telling this other person?
Judge, I got to ask, why is my client being held responsible for something her mother says?
No, because the reason why I'm telling her that, she claims that she's concerned about the mental health. And that's an issue, because that person who said that about her, the only way she knew about this is because you told them. And this is all a family situation. And you're violating my rules, and you're violating the rules on the civil side. And I'm telling you right now, this is the only conversation we're going to have with your violation of these court's rules. Do you understand?
Yes, ma'am.
Next time, I'm not doing a client compliance hearing. If everything is in order, they're going to present me with a motion to revoke. I'm going to sign it. Then we'll have a hearing, and I'll see if they're able to prove it by a preponderance of the evidence. Your attorney will tell you that's the burden on motions to revoke. It's not beyond a reasonable doubt. Do you understand?
Yes, ma'am.
Judge, I have spoken to my client. I spoke with her before the hearing was had. When this incident initially occurred, she knew that this was a possibility. So she hired me. I went into full detail explaining to her, especially in your court, how this works. So she is terrified, and she'll never be back here again.
Mm-hmm. The range of punishment for what you're charges with is up to 10 years in prison for this case. And what gets me is you're an adult, you know the rules, and you're still violating them. That's a problem. Probation. Add MRT to her conditions. Is there anything else?
Okay.
Do you understand the court's orders? Do you understand that there's to be no contact?
Yes, ma'am.
Do you understand that on the civil side, they're saying no contact as well?
Yes, ma'am.
From here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison? If the answer is yes, don't do it. If the answer is maybe, don't do it. Now, the MRT is going to help you with your decision making. And what you should have done with this, and your attorney will tell you, is you should have contacted the people on the civil side and say, hey, these are my concerns. And you should have sent them a letter. These are my concerns. And they would have addressed that. You should have came back to court and say, hey, I have these concerns, and it would have been addressed. Do you understand?
Yes.
And you need to speak to your mother and tell her to stop blaming the party that you had contact with. Do you understand?
Yes.
Well, I'm going to have that conversation with mom.
Oh, yeah, because that does no good for that person and their mental health. So.
Of course, Judge.
Anything else?
Judge, in addition to the MRT, the CSO is requesting field visits be done twice a month instead of once a month, as well as another compliance hearing in 90 days.
All right, we'll have another compliance hearing in 90 days, and the field visits will be twice a month.
Sounds good, Judge.
All right, thank you.
Should I get that date from Norma?
Yes. Norma, 90-day reset for compliance. Albert Dominguez. Deputy, can you make an announcement for Albert Joe Dominguez Jr.? And if somebody checked, is he in custody? Do you know if your client's in custody or not?
I believe he's not here.
Okay.
It was a PR bond. I tried to get some contact info and fortunately got bought out by the Therapeutic Justice Center, so.
Okay. And counsel, you're on this side. Court is calling 2026 CR 009, I'm sorry, 2026 CR 001952, State versus Albert Joe Dominguez Jr. Can I have parties announced for the state?
Megan Calloway for the state.
Defense?
Your Honor, Jeffrey Martinez.
All right, this hearing was scheduled at 9 a.m. is now 9:24 a.m. Deputy, did you make an announcement for the defendant?
Yes, sir.
And the defendant has not answered docket call. Defense, have you had any contact with your client?
I'm not, Your Honor.
State?
Expecting a bond forfeiture.
All right, the court will issue a judge's warrant, remand him without bond. And counsel, you may want to check. I see he does have a case in county court at law number 4. Maybe he's there.
Okay, thank you, Your Honor.
All right, thank you. Attorney Jeffrey Peak. Oh, his attorney is, his client is Juan Manuel Melton.
Yes, good morning, Your Honor.
Mr. Martinez. You need to unmute and show your video. All right, you may want to, there he is. All right, state on page 7, Juan Martinez. Has all the discovery been tendered?
Yes, Judge.
And was an offer tendered? Thank you. And Mr. Martinez, how old are you?
42.
All right, and are you in Bexar County?
Yes, yes. I mean, Your Honor.
No problem. All right, they're gonna tender you an offer off docket. Norma, set this for a plea deadline in 3 weeks, please. You can either put it the first week in May or the second week in May.
Can I interject?
Yes.
I don't know, I think she answered the discovery's been tendered. There's part of the body cam footage that we have not yet received. I've been told it's too large for them to put it in their portal. So we've been communicating with their paralegal, their court liaison. I've yet to receive it. I don't know if they have to convert to a key fob. I don't know if I have to bring by something, but we're still in the middle of that as well.
All right.
Yeah, you can go ahead and give us a drive and we'll provide this videos to you.
All right, Norma. All right, your plea deadline date is going to be May 11th. Defense, you'll need to provide the drive to the state. And you all will need to appear in person on May 11th.
Yes, Your Honor.
All right, is there anything else?
I'm assuming that's a 9 a.m. docket as well.
Yes.
That's nothing else from this defense.
All right, thank you.
Thank you.
Thank you.
All right, Mr. Johnson, Dennis Johnson, if you'll come forward. All right, we're going to have to reset your case. Your attorney started a jury trial in another court.
Yes.
All right. I'm sorry, Odyssey is working slow. I'm trying to bring up your case on the system. Here we go. State on Mr. Johnson. Did you all complete the disclosure or we need to have a hearing on that?
We can prepare. Mr. Cox had not told me anything else about additional subpoenaing of the internal affair files.
All right.
So,
So is this going to be an agreement or?
yes, sir.
All right.
No, it's trial. I thought he told you.
Oh, well, we'll find out if it's trial or what's going on.
Okay.
All right. So he's in jury trial. Are you employed?
Yes, ma'am.
All right. So Norma, recall this for next week and you can appear by Zoom.
Yes, ma'am.
All right. So we'll be back on April 13th. You can appear by Zoom.
Yes, ma'am.
And once you sign the reset form, you're excused.
Yes, ma'am. Thank you.
Just set it for a final plea deadline date and we'll see if it's trial or not. All right, Deputy.
I did.
All right, thank you. All right, the court is calling 2026 CR 002439. And just one moment. And is she on a commercial bond? Off the record for a moment. Is she on a commercial bond? That's okay. All right. All right, the court is calling 2026 CR 002439 State versus Ashley Perez. Can I have parties announced for the record? For the state?
State.
Defense?
Robert Gear, Your Honor, for defendant Ashley Pettis.
All right, this hearing was scheduled at 9 a.m. It is now 9:52 a.m. The defendant has not made an appearance. Deputy, did you make an announcement?
Yes, Judge. She's fine.
All right, counsel, have you had any contact with your client?
We haven't, Judge, but I'll have the office continue efforts on that part.
All right, state?
We're requesting a bond forfeiture, Your Honor.
All right, the court will issue a judge's warrant and remand your client without bond.
Thank you, Judge.
Thank you. Have a good one. Hello. Your client is not here.
Yes, he had contacted me last night. He had a VA services this morning, an appointment. He
Okay.
was asking if the court would reset it. I have verification. I want to.
All right, and we're here for the update as far as, is he not going to participate or,
Was he accepted, Judge?
well, they said he rescinded his application.
I didn't, not aware of that.
So you may want to text him and talk to him about that. Is he already at his appointment?
So yes, Judge, he had a VA appointment at today and tomorrow. Yes, Judge.
I mean, what time is his appointment?
It was at 8:45 this morning.
All right, you want to text him
I will.
and see if he rescinded his application?
Yes, Judge, let me speak with him now.
Oh, thank
Is
you.
it possible to, if I cannot reach him this morning, to reset the matter briefly, just because I have proof that my eyes aren't as good as.
No problem.
Should
Oh,
be able
just
to
text him and see if he rescinded his application. If he did, this is moving towards trial.
Can I go reach out to him now?
Yes, yes, of course.
I just received a message saying that's what people say, conveyed to it, you know, while the little still for the side of the court, parents. That after speak with the
All right.
All right, Judge, I believe. Let me follow back up and I send the court the proof that of his appointment so that we.
No, I want to concentrate right now on the
I
BTC.
mean, if he said that, I believe it.
All right, then it needs to have a trial setting. Ms. Ferguson. On Marlon, we need a trial setting. State, it's criminal trial division. It's one of them. It's tampering and the other is theft of property. How long will that take? All right,
May I approach, Judge?
yes. Hi,
Hi. Thank you for the accommodation from yesterday, Judge, but no luck in getting it.
all right, just a moment. Deputy, could you call, just one moment? Teresa Marie Zamora. Court is calling 2025 CR 011809 State versus Teresa Zamora. Can I have parties announced for the state?
State.
Defense?
Counsel's here, Judge. My client doesn't appear to be.
All right. This hearing was originally scheduled on April 6th. The defendant did not make an appearance. I'm sorry, the defendant did appear, but did not return at 2 p.m. The court recalled this case for today. Defense, have you had any contact with your client?
I have not been able to, Judge, no.
Right. He's making an announcement. Deputy, did you make an announcement?
Yes, Judge.
State?
Judge will be requesting a bond forfeiture.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, thank you. Grant Barron? If you'll come forward. Yes.
Give me Judge, how do you want
Oh, here.
I'm on this side.
Oh, that's not me. Deputies say it's best that it's set up this way for security reasons. All right, on this case, where are we on discovery?
I have everything in, however, I was told that there's certain things that defense may not have, I guess, or whatever, so. If it's okay, we'll just exchange emails, and then if I can't email him the stuff, I'm gonna ask if he can provide me with like a flash drive, and I can get him the rest of the records that he's missing.
It's perfectly reasonable, Judge. We can bring a flash drive next week if we can't sort it out.
All right, Ms. Ferguson, I need a 30-day reset for discovery. And this is Grant Barron.
May I look at my phone, Judge?
All right, and docket is at 9. So you need to make sure you're here at 9 a.m. I see this is your first time here. So you now know where it is, you know about parking and everything, okay?
Judge, would it be okay to do the 8th instead of the 7th? On the 7th, I'm supposed to be in Guadalupe County.
All right, Norma.
Oh, I didn't know we didn't do Fridays.
No,
I'm
we're
also
usually
here on the
trial.
6th.
Norma is the 6th. All right, so Monday, Tuesdays, and Thursdays.
I apologize that I'm picking all the wrong days.
Okay,
I am here on Monday, Judge, Monday the 4th.
Norma, is that? All right, so we'll be back on May 4th.
Yes, ma'am.
Once you sign the reset form, you're excused.
Okay.
All right, thank you.
Thank you, Judge.
You're welcome. All right, Mr. Peterson, we're going to bring you back on Thursday. Your attorney is unavailable today. All right, thank you. Deputy, can you let Mr. Contreras know that his attorney is in trial and we're going to call him back on the 13th? All right, Homer Vasquez Solis. Yes.
Judge, we are not accepting the plea offer. So
Okay. All right, how long is this jury trial going to last?
maybe probably 2. We have some evidence as well.
Okay.
It just for the court's knowledge, I don't know if we are, but we may be starting a trial in the 227th this morning.
Okay.
But I can bounce back and let you know.
All right, Norma. Recall this for tomorrow. All right, thank you. Once you sign the reset form, you're excused.
Thank you.
All right, Mendez Trevino.
Ready.
All right, where are we on discovery?
Judge, there's a newly indicted case where I have not seen the discovery. It's our first setting on that, so I'm trying to make sure we have access to that. It's a more difficult.
Is that the evading?
The evading, yes. This was a pretrial diversion case that got refiled because of the evading case, and I haven't had a chance to. But with one setting, I think I can get up to date on that and find out the facts of that case and any defenses.
Okay, so the new case, that's the evading, correct?
That's correct.
Okay. And then the theft of property, that's the one that's been re-indicted?
That was re-indicted. It was a pretrial diversion. Yes. I do have all the discovery on that case.
Okay.
Judge. I just need to see what the new case is about.
All right, Norm, I need a 30-day reset. All right, we're going to be back on May 7th. Docket in this court is at 9 a.m. You need to make sure you're on time. Do you understand? All right, see you on May 7th.
Thank you. Thank you.
And Norma, that's for 2 cases. Danny Kortsmacki.
Your Honor, present for him. They took him in the back. He's in the wheelchair. cannot hear. So he's, it's first setting, I'm asking for reset so that I can possibly do competency, sanity. And I say that, Judge, just to cover, I've been able to have conversations with him, but just want to,
So you're gonna file a competency eval?
yes.
All right, Norma, I need a reset for 45 days. All right, so you're gonna file the competency or do you want one sent over?
Say that again, I'm sorry.
I said, are you going to file the competency evaluation or do you want the court to send one over?
Whoever's faster, Judge, I didn't have one.
All right, Norma, can you make sure a competency evaluation is sent over and I'll sign it?
That's fast.
All right, thank you.
Thank you, Judge.
You're welcome. All right, who's next?
On page 1, fourth down, Jason Mejia.
Jason Mejia. All right, today is plea deadline date.
Judge, I'm having some discovery issues with this case. There's some CPS records that the state has, I believe has said they've provided to me. I need to review it with my client. We're just asking for some more time.
All right, Norma, call this for a final plea deadline date at the end of the month. All right, once you sign the reset form, your excuse. Thank you.
Thank you, Judge.
All right, Jennifer Humphreys.
Yes, Judge.
And who's the state on this? All right, what's happening here?
Your Honor, defense counsel stating that he needs to bring me a drive for the new #1 case. I'm downloading the videos right now, so as soon as I get those, I can tender to him. And then we should be able to have resolution in that NTR as well.
Okay, and
That's
what's your client's occupation?
What do you do currently, Office?
I'm the medical billing and coding.
Okay. All right, Norma, recall this for the end of the month. All right, May 30th.
Thank you, Your Honor.
Thank you. I'm sorry, I'm not May 30th, April 30th. Thank you. Bashan, that's being recalled for April 30th. All right, are the parties here on Ja Sanchez? All right, court is calling 2025. We'll start with this case first. 2025 CR 015344. In that clause number, you entered a plea to unlawful carrying a weapon with a felony conviction. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. State is opposed to your application, and it's to run concurrently with 2026 CR 002605. Have both parties had a chance to review the PSI report on that cause number?
Yes.
Any objections?
No.
All right. Any witnesses in that case, state?
No, Your Honor.
Defense, any witnesses?
No, Your Honor.
All right, the court will hear argument.
Your Honor, the state is opposed to Mr. Sanchez's application and believe he should be sentenced to the cap of 6 years in prison. He has criminal history. He has done 3 years on 2 cases that grade concurrent, including an assault family second offense that is similar. Additionally, both cases that Mr. Sanchez has pled to involve guns and or gun violence. We do believe he is a concern for the safety of the victim as well as the community at large. Based on his PSI report, he does potentially have ties to gang activity, which also is concerning given his access and use of firearms or possession of firearms.
You too, as well, Rick Baker for the record, Your Honor. The assault.
I'll come to your case. So that's okay, Rick. All right. All right, defense, anything you wish to say on behalf of your client with regards to that cause number?
Yes, Judge. And actually, I mean, obviously, my argument is as to both cases. Is that okay?
Yes.
Judge, I did go through all of the the PSI report with my client, including the TAP evaluation. He understands what the recommendations are at this point. There's no objections to the PSI itself. I think there's maybe some clarifications with regard to his acceptance of responsibility. He understands that he is accepting responsibility. He has applied for deferred adjudication. And Judge, he's asking the court to consider following the recommendation of the TAP evaluation and the PSI recommendations at the end with regard to probation. I think granting him the deferred allows the court to not only monitor him, obviously they're asking for treatment. He understands that, he is seeking that. He understands what SADF means, the time commitment, in addition to the aftercare that is required after that. I think he went into the TAP evaluation very open and honest and seeking treatment. With regard to the actual offenses, Judge, he doesn't, I'm not saying he has clean hands. He doesn't have extremely extensive history. He has been in custody. But again, Judge, he has 3 children, the oldest of which is about to go into the military, and then he has a 9 and an 8-year-old. With regard to the clarifications, Judge, I have not seen the actual protective order. With regard to the 17-year-old, I believe he's graduating. My client would like an opportunity to show his son that he is trying to rehabilitate himself, do well, and see him off. With regard to the little ones, again, Judge, this is based on what my client is telling me. I did not represent him on the protective order, but I believe that there's a caveat, or at least that's what he's telling me, that he is allowed to write letters to the children. So I understand that there's a statement from the complainant. He's indicating, I have not written her. I have asked the children to write me, and I have had sent letters. It's his understanding that he, with regard to the protective order, he is allowed to have that communication with the children. So I've gone over that. He understands that it's not reflecting very well on him, but he does want that clarification. With regard to his gang affiliation, I've asked him, and I think it's my understanding as well. Once you have that affiliation follows you, it's always in the jail. It's always going to pop up. It's always it's a blemish. It's your A on your shoulder. So he's indicated that yes, I have that affiliation. I've asked if it's active, if he's still involved. He says no. That's something from my younger days. But obviously I'm affiliated through. It's going to pop up on a gang check. So he's certainly not indicating that is something that he's currently involved in.
And did he abuse the mother of his children in front of the children in a vehicle?
They were en route to.
En route to pick them up? Okay.
Yes, Judge. But I do believe that he still has communication with them and he seeks to have that relationship. Again, Judge, I've gone through this extensively with him. He understands the chance that the court would take on him if you were to give him that chance. But he is more than willing to abide by any type of conditions that the court deems appropriate. He has been in custody, I believe, close to 3 to 4 months. I don't believe that there's a wait for Saturn. He understands that he'd have to do that. Again, he understands that the time. So I asked the court to consider that as a sort of punishment as a condition of his probation.
Okay. All right. And then Rick, because she addressed that.
Yes.
So then we're also on the record in 2026 CR 002605. And what would you like to say?
Most of what I said had been addressed by Ms. Espinosa already, and I was also going to add something that Your Honor pointed out, is that the mother of the children is the one that he was abusing on the way to school to get from. They were not in the car, but this is still the mother of the children that he's saying he wants to contact with. Additionally, Your Honor, she is still in fear for her safety. That this has been not the first. This is the guy.
Rob
in the
Hamlin?
wheelchair. He's in the wheelchair, Judge.
Yes.
Kelly Peddle's in the other court and asked me to get with you on 2 cases. They haven't brought him over yet. Can we recall this for Thursday?
Deputy, is there a reason why he's never here?
Judge, I think today they have so many people in wheelchair. You know, trying to place it.
All right, recall him for tomorrow.
I'm gonna be here Thursday and Kelly can be available Thursday.
All right, recall it for Thursday and tell them he needs to be at the top of the list. What is happening with this case?
We got an offer. There's some issues there. The state was looking at them. I have to clear it. One of the offers was kind of high. We'll see. He's in a wheelchair. He's disabled and all that. Seeing if we can work out something a little better when he gets here. But we can't proceed until he's here. I've already done a jail Zoom with him. Kelly Peddle has, and we just need him here and see if we can run it out.
All right, thank you.
He's in custody.
Okay.
All right, thank
Thank
you. All right, Thursday.
Yes.
All right, I'll go down and tell Kelly right now.
All right, thank you.
Thank you.
Hey, how's it going? Yes.
Got a motion for judgment on tongue. This is a guy that was sentenced back in January. It's 2 years TDC. And you included
Oh, so the thing about this, you'll need to speak with the state to see if they have any objections. And then if they don't, but I believe this is, was this family violence?
sorry, it was, but it's not her. She's not the victim.
Okay, if you'll talk to them.
Okay.
All right, sure. I think Rick is around. If you ask Norma, she'll call Rick and Rick can come down.
I'm sorry, Judge.
If you talk to Norma, she'll call Rick and Rick can come down.
Oh, okay. That's who I need to talk to, I take it.
No, I mean, you can talk to anyone in family violence.
Oh, I see.
Megan Sanchez. All right, where are we on discovery?
Judge, this is, first thing I was informed, following that there's, some additional photographs and surveillance, on Verific and Nixon. So I need time to access those.
All right. Norma, I need a 30-day reset for discovery.
Yeah.
All right, we'll be back on May 7th. So here's the thing, court starts at 9.
Yes.
So now you know where the courtroom is, you know about the parking situation, and you know about the line. So make sure you're here on time, all right?
Yes.
All right, thank you. Once you sign the reset form, you're excused. All right, court is calling 2025 CR 011309C and 2025 CR 011311A, State versus Lincoln Merchants. Can I have parties approach and announce for the record for the state?
Orlando Gostignon for defense.
And are you Lincoln Merchants?
Yes, ma'am.
Counsel, have you received all discovery in each cause number and did you review it with your client?
We reviewed, our discovery judge, we received, I believe, everything.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Mertens, in each cause number, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do.
State, are you proceeding on the indictments as presented?
We are.
Mr. Mertens, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In each cause number, you're charged with aggravated robbery. Range of punishment in each cause is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause number?
Yes, ma'am.
In each cause number, the court would grant your application for deferred adjudication. If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He's been able to assist me in his defense, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Mertens, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering in these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea in each cause number, the cases are to run concurrently. And they are so to run concurrent with 2025 CC 009793 and 2025 CC 009791. And the state will take in consideration 2025 CR 011310A, and punishment is to be assessed at a cap of 10 years in the prison. And if the court finds from reviewing the documents that there was a weapon used, the court will find that there is an affirmative finding of deadly weapon. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Judge, just to clarify, I think there were 3 cases that were going to be taken concurrently. It should be the other aggravated robbery as well as 2 misdemeanor cases. If I mislabeled the plea paperwork.
I believe they had 3
Was there 3?
cases in there. I think she was reading off concurrent on the 2 misdemeanors.
Okay, my apologies.
Yeah.
Yes, that is the plea.
All right. And there's only one case that's being taken in consideration. Is that correct?
That's correct, Judge.
All right. And then did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Judge.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, in each cause number, do you have any evidence to support the defendant's guilty plea?
Yes, Judge. Well, for State Exhibit 1 and all attachments in both cases.
No objection, Judge.
All right. And state, have you spoken with the complainants?
We have, Judge.
All right, state, you may be excused.
Thank you.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Defense, are you asking for a PSI?
We are, Judge.
Is there a need for a MIC evaluation or TAP evaluation?
TAP evaluation, Judge.
All right, I need a PSI and TAP date. All right, probation, how much time do you need?
I'm sorry, 6 weeks.
6 weeks?
May 19th, okay.
You're fine with May 19th?
Yes.
Is May 19th good for you?
Yes, Judge.
All right, we'll come back on May 19th.
Great, Judge. Thank you.
And that'll be a PSI and TAP evaluation. All right, what will end up happening is probation will come to speak with you. They're probably going to speak to you more than once because there's more than one evaluation they have to do. I'll base my decision on your application based upon any evidence that's presented. All right, any questions?
No, ma'am.
All right, thank you. We'll see you back then.
Thank you, Judge.
Have a wonderful day.
Oh, thank you. You too.
Hey, Judge, we're just on both act robbery.
Yes.
Thank
Hello, Mr. Atwell. All right, court is calling 2025 CR 013125 State versus Charles Atwell. Can I have parties announced?
Fernando Cortez for Mr. Atwell, Your Honor.
Are you Mr. Atwell?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Atwell, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the punishment enhancement and as also count one and proceed solely on.
Any objections?
No, your objection, Your Honor.
All right, Mr. Atwell, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
All right, off the record for a moment. So there won't. All right. So did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, your charge is possession of a controlled substance. Penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am. I take full responsibility.
All right, counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he is currently competent
I do,
and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Atwell, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2 only. They're asking that your punishment be assessed at 7 years in the prison. There's a $1,200 fine, and the state is opposed to your application for community supervision. Did you understand that to be the plea?
Community supervision is.
They are opposed.
They're opposed.
So the state will say that they don't want you to be on probation. Do you understand that? And your attorney is going to be arguing that you receive probation. Do you understand that?
Yes.
So if the court decides not to grant your application, the court can sentence you to the 7 years in the prison. Do you understand?
I understand.
All right. Did you understand that to be your plea? Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Understand.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I understand.
Counsel, have there been any such motions?
Judge,
Have there been any such motions?
no, Your Honor.
Then to the offense and count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, sir. State offer states exhibit 1 and all.
No objection, Your Honor.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right, counsel, it will be 6 weeks for us to do a PSI, or if you want to come back sooner, you can come back sooner, and the state will present any criminal history to me or whatever else they have to present. Or do you want a full PSI?
I'd like the full PSI, Your Honor, please.
All right, I need a PSI date.
May 19th.
All right, we'll be back on May 19th. And counsel, I'm sorry, can I have the trial court certification I gave you back? All right, thank you. All right, we'll come back on May 19th, and that's for a PSI and TAP evaluation.
Yes, Your Honor.
All right, so what will end up happening is someone from probation will come and visit you. They'll maybe visit you more than once. Just make sure you speak with them. All right?
And that's to see if I'm approved for probation.
No, the only thing the PSI and the TAP evaluation does for me, it's sort of like a pre-sentence investigation report. So that report will tell me things about you that I currently don't know. And they will usually ask you questions about your family background, the TAP evaluation. They'll ask you about your drug use. Has there ever been any type of drug use? They may even just as a precursor, ask you about any mental health issues. And then what will end up happening is when I receive that TAP evaluation, their report usually will say something along these lines. If you give this person probation, this is what we're recommending. And the PSI will say, if you give this person probation, this is what we're recommending. But they're not the person who makes the decision on whether you receive probation or not. That's me.
So after you evaluate all of that,
Yes, I'll
come back on the 19th.
Yes, you'll come back on the 19th. And even though I'm evaluating that, before I even evaluate it, your attorney will have a chance to look at it. The state will look at it and they'll tell me if there are any mistakes in it or things that they think maybe there's a different spin that should be placed on it. And then if the state wants to bring in witnesses, they'll bring in witnesses. If your attorney wants to bring in witnesses, he'll bring in witnesses. And then I'll make my decision after I hear everything. Okay. All right, thank you. You're welcome.
Thank you, Your Honor.
All right, the parties on Shepherd. Court is calling 2023 CR 10058, State versus Andrew Shepherd. Can I have parties announced for the record?
Brandon Britta with the state, Martin Guerra, attorney for Andrew Shepherd.
All right, and are you Mr. Shepherd?
Yes, I am.
Okay. All right, Mr. Shepherd, you have a constitutional right to appear in court in person. Did you review the defendant's consent to enter a plea by video conference with your attorney? Did you understand it and electronically sign it?
Yes, I did.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Shepherd, did you review the application for deferred adjudication with your attorney? Did you understand it and electronically sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Shepherd, did you review the court's admonishments with your attorney? Did you understand it and electronically sign it in all the appropriate places?
I do believe so, yes.
All right, your charge of possession of controlled substance penalty group 1 to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court grants your application for deferred adjudication, if for any reason your deferred adjudication is revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Shepherd, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yeah.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, I understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at a $1,000 fine, probated, and the state recommends deferred. Did you understand that to be your plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
All right, the court recalls that there has been only one motion that was filed and heard and ruled upon. Is that correct, counsel?
That is correct, Your Honor.
All right, outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the DOEP course, and the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
You're asking me, right? That's guilty.
All right, is he pleading guilty?
Yes, Your Honor.
All right. State any evidence.
Judge, you're up to say exhibit number 1, including all of its attachments.
All right, state you may be excused.
Thank you.
No
Did your, thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find that there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask you take note of the fact he's accepting responsibility, he's pled guilty. This amount seized was just 1/10 over the threshold for third degree. Respectfully ask that you follow the plea bargain.
All right. So, Mr. Shepherd, what county are you in?
I'm in Wilson County.
That's in Tennessee, Your Honor.
I'm sorry, where?
In Tennessee.
Okay. I was just gonna say. Do you have any children?
No.
Are you employed?
Presently, no.
All right, so how do you support yourself?
I DoorDash right now, and I live with family presently. So
Okay,
I'm looking for a job though.
okay.
Actively looking.
All right, this is what the court is gonna do. The court is gonna sentence you to 2 years deferred adjudication. There's a transfer to Wilson County in Tennessee. 100 hours of community service restitution for every sober support meeting you complete. 1 hour will be deducted from your community service restitution. There's going to be a TAP evaluation, out of custody, follow TAP recommendations, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. If applicable, then there's to be field visits 1 time per month for 6 months. Probation, is there anything else? Okay. Is there anything else you need from the court in order to be successful?
Me?
Yes.
No, I think that's all.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and
Yes.
sign it? Because this is a
Yes.
plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. I'm sending you to breakout room number 1. Probation will meet you there and go over your conditions.
Okay.
All right, thank you, counsel.
Thank you, Judge.
Anyone else ready?
2, please. 5 minutes.
Okay. All right, so you all here on Carver Hall,
Carvajal, yes, Judge.
what is happening?
Okay, on this, may I approach a little bit?
Yes.
On Mr. Carvajal, I was told by Ms. Galloway, I think it was probably during last week's Cantu matter, that they had new discovery that I needed to bring them terabyte drives for.
Okay.
So at this point, I brought them 2 terabyte drives. They filled both of those and they need a 3rd terabyte drive that I'm going to bring this afternoon. So I guess my announcement is we're still getting voluminous discovery.
All right.
Sounds like a lot. If it's 3 terabytes of stuff, it's a lot. That's a lot of stuff.
All right, Norma, recall this for May 19th.
Just real quickly.
I will be I leave town on the eighteenth.
Oh, it's just for discovery,
That's okay.
to make sure that you
I'll have
all have
Lindsay,
it.
I'll have Lindsay here.
Okay.
Or his co-counsel.
That all sounds good to me. Are you guys gonna upload that into e-discovery or only put it on Drive?
It's on e-discovery. I
Okay.
think it's just,
For convenience on the
It's-
Drive. Okay.
there,
Like a lot.
the facts of the case make it a very robust discovery.
Okay, we'll keep working on it.
All right, and is this the co-defendant of the person who just entered a plea?
That's correct, Judge.
Okay.
And that was one with about, I think, 50 pages of discovery disclosures.
And you're gonna, you have to upload it, but you're gonna upload it.
Oh, it's all uploaded in the very.
Just things, you'll need about 15 days to download it all.
Oh, well.
That was the estimated download time was 15 days. Wow.
24.
Yeah. So I said, forget
Okay,
that.
you know what? I could solve the discovery issues so quick.
Your museum,
You can solve a lot of things with it.
All right,
So
so
May the 19th.
May 19th on
Okay.
Mr. Carvajal, and I'll note that
No,
you,
I won't be appearing.
you won't be
Okay.
appearing.
But I'm
All
gonna bring
right.
a third drive to the court, this afternoon, we're gonna drop off a third drive.
All right, then that leaves, you have Mr. Ramos as well.
I have Rodriguez.
Yes,
Yes, not Ramos.
sorry.
Yes, we're talking.
We're confirmed.
Judge.
Okay, all right, thank you. All right, who's here on Crenshaw? Are there any applications on this? Is there going to be a need for PSI?
No, Judge.
Okay. All right, the court is calling 2025 CR 013304 and 2025 CR 016023-02 State versus David Crenshaw. Can I have parties announced?
David A. Garcia, attorney for David Crenshaw.
Hello, Mr. Crenshaw.
Hello.
Are you Mr. Crenshaw?
That's me.
All right, counsel, have you received all discovery? Did you review it with your client?
I have, and we have, Judge.
Court will find that the state is in compliance with discovery. Mr. Crenshaw, in each of these cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do on both cases, Judge.
State and cause number ending in 04, the evading, are you proceeding on the indictment as presented?
Judge, we're waiting the punishment.
No
Any
objection.
And the cause number ending in -02, are you proceeding on the indictment as presented?
No objection, Judge.
All right. And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, and the cause number ending in 04, you're charged with evading arrest detention with a previous conviction. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in -02, you're charged with unlawfully carrying a weapon with a felony conviction. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have pleas with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, ma'am, I did.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, and he is.
Mr. Crenshaw, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, they have not.
Anyone promised you anything other than the plea?
No, they have not.
Are you satisfied with the way you've been represented?
Definitely have.
I'm sorry?
Yes, ma'am.
All right, if you're not a U.S. citizen, by entering these pleas, you will be deported for non-naturalization and re-entry. Did you understand?
I do.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
I did.
Okay, according to the plea and the cause number ending in 04, punishment is to be assessed at 207 days in the Bexar County Jail under 1244. There is no fine and no applications. And the cause number ending in 04, according to your plea, punishment is to be assessed at 4 years in the prison. There's a $2,000 fine, no applications, and this will run concurrently with 2025 CR 016022-02. Did you understand that to be the plea?
I did.
Defense?
It is, Your Honor.
State?
Judge, the other cause number in 02, I'm not sure if I even know if it's unique difference.
Oh, no, you wrote it correctly. I did not read it correctly.
Okay.
So that will be taken in consideration, 2025 CR 016022-02. And these cases will be running concurrently. Did you understand that to be your plea?
I did.
All right, defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do.
Counsel, any such motions?
They've been filed but not heard, Judge.
And the cause number in 04, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ending in -02, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
States one in attachments.
We reviewed states one and all attachments in both cases, Your Honor. We have no objections.
All right, state, you may be excused. And each of the cause numbers, did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I do.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In cause number 2025 CR 013304, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing in that cause number, counsel?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, my client understands he made a mistake, made some poor decisions. We were set for trial. We were ready to go to trial, but we were able to work with the state and work out a deal that I think works out for both parties and society. We're asking that you follow the deal. And he's been in for quite a while, so we're asking, and I believe the state's in agreement with that the judge would be satisfied.
All right. Under that cause number, the court will sentence you. Well, the court is finding you guilty. The court will sentence you to 207 days in the Bexar County Jail under 1244. Give you credit for any time served. Court will show that the judgment is satisfied. This is run concurrent with 2025 CR 016023-02. There's to be no residing in households with minors and no unsupervised contact with minors. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I do.
All right, next we're going to proceed in 2025 CR 016023-02. All right, in that cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, anything you wish to say on behalf of your client?
I believe you've heard it all, Judge.
All right, the court will follow your agreement, sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 013304. Taking consideration 2025 CR 016022-02. I recommend the therapeutic community. That's to help you with any issues you may have, be it mental or any drug issues. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal and that cause number? Did you understand it and sign it?
I do.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Make better decisions, okay?
Yes, ma'am.
All right.
Thank you, Judge.
You're welcome.
Good luck. All right, here you go. Here's your copies.